Hello and welcome to the channel. Today's case is RSM, a child, on the application of R versus the Secretary of State for Home Department 2018 EWCA CIV 18. About the case. The case is about the Secretary of State's obligation to an unaccompanied child asylum seeker called RSM under an EU legislative measure known as Dublin III. This measure specifies how member states of the EU are to determine which of them is responsible for processing an asylum application. The first stage in the asylum process is to determine which state should examine his claim, and the second stage is to determine the claim itself. So, about the facts of the case. RSM, when aged 13 years, had travelled to Italy from Yemen with an adult called SB, his father's cousin. He was originally from Eritrea. He and his mother and younger brother had left Eritrea some years before and gone to Yemen, but they had to flee Yemen because of the civil war there. They decided to go to Italy by boat. RSM travelled with SB, his father's cousin, and arrived in Italy in April 2016. But his mother and younger brother were drowned, taking a similar journey in June 2016. RSM claimed asylum in Italy, which began the process to determine his claim. He was accommodated at the time of the proceedings by the Italian authorities in Rome. The Italian authorities went no further than the first stage. In August 2016, SB and RSM made it clear to them that RSM wished to live with his aunt, called ZAM, who had obtained refugee status in the UK. On the 13th of September 2016, RSM was officially recognised by the Italian authorities as an unaccompanied minor. He was given the date of 4th of January 2017 for the next stage in his asylum claim, which was an asylum interview. The respondent, ZAM, for herself and in her capacity as RSM's litigation friend, asked the Secretary of State to approach the Italian authorities so as to take over RSM's asylum claim under Dublin III. The Secretary of State took no such action. These judicial review proceedings were brought in November 2016 in the upper tribunal to force the Secretary of State to take action. In any event, RSM is now living with ZAM in this country, and this appeal will not affect his position in any way. This court permitted this appeal to continue because the upper tribunal has made similar orders in other cases, and Secretary of State wishes to test the extent of the obligation imposed by Article 17.1 of Dublin III, and also the effect of the European Convention on Human Rights. The fundamental issue is whether the Secretary of State should have taken proactive steps using powers conferred by Article 17.1 to short-circuit the process that might otherwise apply to bring him from Italy to the United Kingdom. The court considered a number of provisions and gave a very detailed decision. Firstly, on the issue of Article 17 of Dublin III, the question there was, did the upper tribunal err in law in deciding that there had been a failure by the Secretary of State lawfully to exercise the discretion conferred by Article 17? And the answer was yes. The upper tribunal misinterpreted the ambit of Article 17. Article 17.1 is intended to preserve the sovereign power of an individual state to examine an asylum claim that, but for the terms of Dublin III, it would otherwise be entitled to examine. It does not give the Secretary of State a general power to step in to override the operation of Dublin III process in another state whenever it could be argued that the process was causing significant delay. In the present case, RSM was not present in this jurisdiction and was not entitled to have an asylum claim considered by the Secretary of State. Accordingly, the upper tribunal was wrong to find the Secretary of State had the discretion to exercise under Article 17.1. The next point was considered was whether Article 17.1 has any, and if so, what application in the case of a third country national or stateless person not present within the territory of the United Kingdom. And the answer to that was that Article 17.1 has no application in such circumstances, but this is without prejudice to any other power of the Secretary of State to entertain an asylum application in circumstances to which Dublin 3 does not apply. The court then considered if Article 17.2 has any, and if so, what application in the absence of a take charge request from another state. And the answer to that was no. Article 17 has no application in the absence of a take charge request from another member state. Thank you. That concludes the review of the case of RSM. Please subscribe to the channel.